Yes, Mr. Booth.
Thank you, my lord. So we were on the 6th of June email. I think my lord asked me whether it was referred to in H2 or H3. It's referred to obliquely in H2 at page 434, paragraph 61. 434, paragraph 61.
Is this paragraph 61 of H2?
H2, yes. And it's referred to because the tribunal refers to Mr. Sully's witness statement.
61.
434.
Mr. Sully says, Vincent Mason reviews the situation. Yeah. Okay.
And then at 62, the tribunal makes 2 points. First is, it's their conclusion that the child's version and the adult's version were substitutes. But we say for the purposes of this argument that doesn't matter. And secondly, the error is not material, provided that AMCO did not promise to keep a rival product off the market. AMCO, of course, are adamant that no such promise was ever made. What doesn't happen here is that the tribunal does not go on to cite the 6th of June and to the fact that the terms were recorded by the external solicitor. Anyway, that is the reference in H2. And then obviously in H3, this is a page 387. This is in the long paragraph 134, where the tribunal sets out quite extensively advances submissions concerning the contemporaneous documents and what cross-examination had or had not been made. And we'll come on to have a look at the cross-examination in a moment. But clearly the 6th of June date and telephone call is referred to in the first bullet point. And
Sorry.
I beg your pardon. So this is H3, page 387.
134.
Yeah, the paragraphs are quite lengthy.
Tell me about it.
It's internal, page 87.
So it's 134, page 87 internally.
Internally. Yes. For the bundle, I think you just put a 3 in the front.
Yeah, okay.
And it's the first bullet point on the 6th.
This is a citation of what was put in writing in advance of submissions.
Yeah, we see that from
page 385. So all of this is a citation right the way through to 388 from advances written submissions at the hearing.
Yes, so on 385, he says, the tribunal says, that could only be done by a detailed passing and cross-examination of Mr. Baton's evidence.
Right. Okay.
Okay.
Yeah, okay. And as my lord says, this is a citation from our submissions where we say, look at all this contemporaneous these documents. The witnesses who were saying that the second agreement recorded the whole bargain, the cross-examination with the greatest respect was not detailed enough. And on 387, we refer to the 6th of June email, and we'll come to the cross-examination. And I'll also refer, my lords, to the 18th of June email in the second bullet point. And the tribunal, we shall see, when it came to the due process hearing, did refer to these two emails, 6th of June and the 18th of June. And as my Lord said, this is we see this is what we have written, because that is page 385 in the middle. On this basis, we turn to what was written by Advance. And then it's important to see at paragraph 135, at 388, given the rules regarding cross-examination set out in section E, there was a failure on the part of the CMA to observe the principles of due process, fairness and a need for an appeal process with evidential integrity required that the essential findings be put to Mr. Baton, and less importantly to Mr. Sully, but they were not. So we'll come back to the implications of not challenging Mr. Baton's evidence on this. So can I just for the moment leave the two judgments and start to address my lords on issue 1B, and this 6th of June email is all part and parcel of issue 1B. And as I said earlier on, the issue is the witnesses stated on oath that the written agreements recorded the whole bargain between Advance and Auden. That's what they stated on oath. And the tribunal found that this evidence was coherent. And because their evidence had not been properly challenged, the tribunal did not disbelieve them. We'll come on to it. It's the basic principle of paragraph 12.12 of Phipps and non-evidence. Now, on the written agreements, I'd like to identify the issue, because listening with the greatest respect to Mr. Turner, there is still some confusion on this. And I would like to identify the issue by reference to the CMA's defence and what the tribunal said. So if we go first to the CMA's defence, bless you, and that is an agreed supplemental bundle volume 3. That's at page, I'll give the two references. So the electronic is 1083 and hard copy I believe is 1070. So I think the electronic is 1083 and the old hard copies, as my hard copy reflects the electronic, I think the old hard copy is 1070. And there you see the CMA's defence. It's a lengthy defence, and it is signed by no less than 1, 2, 3, 4, 5, 6 counsel acting for the CMA on page 1309. Now, if we go to page 1107, so that is 1094 for the hard copy, so 1107, paragraph 47, to see what was represented to us and to the tribunal. So, at paragraph under agreement by Waymade and AMCO to forego independent entry. 47. In return for the substantial payments made by Auden, Waymade/AMCO agreed not to enter the market independently with its own 10 mg hydrocortisone tablets. Importantly, this part of the bargain was not recorded in the written agreements. It is, however, demonstrated by the contemporaneous evidence and subsequent interview evidence explained in detail in the decision. And we get the same old mantra, no credible explanation for the payments has been provided by the parties. Well, we say there was a credible explanation, but the important point for now is this part of the bargain was not recorded in the written agreement. That is the case that we were being asked to meet. I go on, and it is all referenced.
Being very portentous about it, but it's fairly simple.
It is,
Yeah.
but when one listens sometimes to the submissions by the CMA, we get, well, there was no side agreement. And so...
Well, it's just nomenclature.
Yeah.
I mean, you're all arguing until you're blue in the face about tags.
Collateral understanding, side agreement, goodness only knows what else. What matters is whether it was agreed. It doesn't matter what label you put on it.
But that's the point. What was agreed? Because we say what was agreed was the second written agreement.
Not a
Well, of course you
contractual
say that,
agreement.
but they, you know.
It's not a contractual agreement, Mr. Freely. This is competition law. You know what it is. You understand what the Chapter 1 prohibition is. It doesn't involve a contractual agreement. It involves something that is a nod or a wink or an understanding.
But
I won't enter the market. You pay me lots of money. That's the deal.
Well, of course that is correct.
Yeah.
And no one is pushing back. I mean, there may be some submissions as to what crosses the line. I'm not disagreeing with the nod and the wink.
So why are we descending into all this sort of, as I say, portentous examination of the way it was put here or the way it was put there? It's perfectly clear what they're saying.
Well,
and you know, your juniors may nod fiercely as they like, but the fact of the matter is, it's perfectly clear. It's a lead allegation that there's an agreement, an understanding, a nod or a wink or something outside the terms of what the people chose to write down, which says you won't enter the market. As it says in your, by the way, in your own legal advice.
I will respond. Can I understand that my lord is saying it's clear, but can I just continue with a few more passages?
You may take your own course for a day and a half, Mr. Breedley.
It is a lot deeper than that. It is not as simple as that, because the question is, was the nod and the wink put to Mr. Bayton? Because Mr. Bayton is saying, look, all I did was agree the second written agreement with the help of my lawyers. You can look at it from a corporate perspective here, a company perspective. It wants to ensure that a supply arrangement is competition law compliant. It instructs external solicitors to assist in the negotiation and the recording of the terms. It goes away, the agreement is in the top drawer. Then comes along an allegation where you agreed a different and broader term or understanding or nod and a wink. And the company director and the general counsel says, well, no, we didn't agree a different or broader understanding. What we agreed was in the terms of the formal, I emphasise formal, agreement. And can I just show the court a few more passages? So at page 1116,
Paragraph?
78, 79 and 80. The CMA in the defence say that we, the appellants, rely extensively on the second written agreement as recording everything that was agreed, i.e. there was no nod and a wink, there was no hidden term or whatever. Now, they do not assist the appellants, they do not preclude, and are not inconsistent with the finding that the parties shared a common understanding that the payments by Auden were contingent on foregoing independent entry, which was not recorded in the written agreements. Now, going back to paragraph 10.115 of the decision, it is that common understanding that is not disclosed to Pinsent Masons. And then the last passage in this defence, paragraph 86 on page 1117, 1104 of the hard copy, but it's page 86. So this is now the CMA is addressing the terms of the written agreement, and we'll see this in a moment. Clause 2.2 of the second written agreement stated that AMCO was required to give 3 months' notice to Auden if it wanted to supply its own hydrocortisone in the UK. Sinvan and Advance complain that the CMA has not explained how that term, which is not alleged to be unlawful, I'll come on to that, differs from the common understanding. And we go over to 87. The purported comparison is inopposite because it again wrongly elides the second written agreement and the 10 MIG agreement. And again, this is under the heading, the unlawful 10 MIG, nod and a wink or whatever, is easily distinguishable from the second written agreement. And then we get 88, clause 2.2, required AMCO to give 3 months' notice to Auden if it wanted to supply its own hydrocortisone in the UK. And clause 17.2 allowed Auden to terminate the supply agreement on the same notice period. The CMA did not find those terms in the context of the second written agreement by itself to be unlawful.
Yeah.
But that does not prevent the finding that a different and broader common understanding, defined as that AMCO would forego market entry, was unlawful. So it is quite simple in the sense that Advance negotiated, we saw this the 6th of June, an express reservation of right, a contractual right, to enter the market. It insisted on that right, that there would be a non-compete exclusive purchase obligation. There were various legitimate reasons why they concluded this, but they did. But there was an express reservation, contractual reservation, to enter the market. And the broader and different understanding is essentially that you will not exercise that right because you are going to forego independent entry. And that is why in the defence, the CMA say it is easily distinguishable. You reserved a right to enter. We saw that on the 6th of June, and we'll see it in another email. And it's Mr. Baton's evidence, but you are having a different and broader understanding that you will not exercise that contractual right. And that had to be put to the witnesses. And when they say, well, all we did was have clause 2.2 and we had an express reservation of a right to enter, what had to be put was no, there was a broader and different understanding that you would not exercise that right. And it's very, very important in the corporate world. You feel that you've instructed solicitors to assist in what you think is a formal binding agreement, and then you're told you had a different and broader understanding. And that is why, if we, and I should just, in paragraph 88, there is a distinction there between clause 2.2, the CMA did not find those terms by itself to be unlawful, but the unlawful bit was a different and broader common understanding. Very, very important. If if you accept that the formal agreement that you have signed is not unlawful, but you are alleging that the parties to that agreement have got a different and broader unlawful understanding.
Can you just help me with the interpretation of this paragraph? And in fact, it reflects perhaps the decision. And we've seen some equivalent statements to this effect. Is that this isn't a positive statement by the CMA that it's lawful. They're simply saying we're not focusing upon this because, as they say in paragraph 81, this is just part and parcel of a wider series of bits of evidence which we say is the overall understanding. Well, I don't think it's a positive statement of legality, is it?
Well, and with the greatest respect, I would submit, as we do in our skeleton, that's an incredible, uncharitable distinction. Because you sign an agreement which the CMA says is not unlawful.
It's the CMA's approach. I mean, the question is, did the CMA say the agreement was lawful? I don't think they did. They just simply said it's part and parcel of a series of things.
No, they said it was not unlawful.
Yeah, that's not the same as saying
In
it's
itself,
lawful.
by itself.
Yeah. It's what the target is of their investigation. I think that's a distinction.
Well, I think so.
Well, we were talking about snook and what the common person would understand, and if you look at an agreement, you say, well, that's not unlawful. The flip side of that is surely that it is you're accepting it's lawful, particularly when this is a quasi-penal infringement where you get serious penalties and reputational damage.
But surely the problem, Mr. Brealey, is the fixation about the second written agreement. The second written agreement was simply one step in a path from first you buying product at a commercial price from Borden. Second, you entering into a highly anti-competitive agreement in relation to exactly the same thing, just a bigger tablet, on highly uncommercial terms. The third was you getting a market authorization to manufacture 10 milligram tablets yourself. The fourth was the reduction in the price from a highly commercial price to a ridiculously knockdown price, £1 a packet. The fifth was that sometime later you decided to enter into a written agreement which is neither here nor there to anything. It just continued the arrangements for a further 2 years. And those are the chain of events recorded in Hydrocortisone 2. And fixating about what you chose to write down with lawyers' advice is not the story. The story is the whole story. We have to look at the whole story. And you're starting in the middle. Now, you said something interesting, which I want you to elaborate on. You said, not only do I start in the middle, so does the CMA.
Yes.
And if that's the case, then you need to show us that and explain why they've, I used the word fixating, it's not polite, but I'm going to use it again, why they fixated on it too. Because if that was the stage of the argument, and it's nothing to do with you, and it was all to do with them, maybe one other point.
Well, that is a...
But I mean, if we go back to what you were showing us earlier in this defence at paragraph 47 and 48, we're picking up on my Lord's point. First thing that they do in 48 is to go to the 20 mg agreement and say that the 10 mg agreement was an extension of that. So they start in 2011.
Well, I would like to start in 2000. I mean, Advance has got nothing to do with the 20 mg. It inherited an unwritten 10 mg. And I was going to start at the beginning of the alleged infringement, and I will do that. I'm focusing on the second agreement because the CMA's submissions didn't hardly touched on October 2012 onwards. It focused on the second written agreement and the 7 emails, April, May, June, And that was it. So you get a snapshot of the narrative and you don't go back. And I will do
Sorry,
it
what are you saying? They focused on it in their submission.
yesterday and today.
Yeah, yeah.
The seven emails
Yeah, 7 emails.
are basically April, May, June 2014.
Yes.
And we say, well, look at Annex 1 to our closing. There are probably 1,000 emails in Annex 1 alone relating to the period October 2012, 13, early 2014. And I will refer the court to some of those later on this afternoon, if not tomorrow morning.
Yeah.
But all I'm trying to do, I'm trying to do two things. I'm trying to support what the tribunal decided in H3, because we haven't really heard anything from yesterday or this morning about how the tribunal came to the conclusion that there was no infringement as regards the written agreements. And just the punchline is that Advance, through its lawyers, wanted to cover themselves. Maybe we should just have a look at the paragraphs, but I do feel that we should look at the cross-examination of the written agreements. But just so that the court
Well, we
knows,
saw that this morning. That Mr. Baton said, I
No.
wanted to cover myself. I mean, of course he did. Every commercial man wants to cover himself, particularly if he thinks he's doing something radically anti-competitive.
well, that's
I mean, you don't need to be a competition lawyer to know that buying product worth 60, 50, 30, 70 pounds a box for £1 looks a bit fishy.
well. That is why
Do you?
in H2.
Yeah.
That is why in H2 the tribunal said the inference from the value transfer was a strong one.
Yes. Wasn't just the value transfer, it was
Well,
all the
the
things I
relevance
put
too.
to you earlier.
Well, but the trouble with that is that we had also lots of things to put to the CMA as to why the inference was wrong.
Well, you're going to show us that.
Okay, so will the court just allow me just to show?
Take your own course, Mr. Brealey.
I understand.
I will take a vow. I will take a Trappist vow.
But it is important because both
Till
the
about
General
4 o'clock.
Counsel, both
Till about 4 o'clock.
it's about 4 o'clock. If you give me the indulgence of 10 minutes, because if I don't put the case,
No,
then
no,
I
I
haven't
want you
put the
to. We
case.
want to understand.
And I would just like to emphasise that both the General Counsel, Mr. Sully, and Mr. Baton, the CEO, went on oath and said, look, we did not have any side agreement. We did not have any different and broader understanding. All that we
Well, he
agreed...
put it differently. He said that was the deal, but I never told him that. So nothing crossed the line. So somebody told him things had to cross the line because he said okay, but didn't cross the line.
Well, that then leads into one of the problems is what you get one flip flops from all sorts of things to another. If my lord is referring to the 15th of June email,
Well, I'm referring to
for
the
example.
cross-examination we read this morning.
Yeah.
But, yeah.
well, but that is all to do with the second written agreement. It is not. When one looks at the email, you weren't shown the email.
Yes, we were. I asked to see it yesterday.
Yeah, we saw the emails.
Anyway,
Was that? I don't know whether the 15th of June is in that pack.
I don't know. I haven't
It
the
is,
fact.
is it? It is in the bundle.
Yeah, 2000 something.
Yes, it's in the pack.
Yeah. Miss Ford is going to deal with this. let's just have a look at the
In the context of
26, yes. 26 of
tab
26.
tab 7. I don't know which day this is, but day 2, I think, possibly. Day 3.
Can we, I can't recollect seeing
Day 3, I think, and we were shown passages beginning at page 22.
And Miss Ford is going to deal with it, but can I just flag the point? Because clearly the court is very interested in this, if not, I'll launch my own.
Yeah.
And that is the supplemental bundle, the agreed supplemental bundle, at page, we start at 2401. If the court could just cast it over those 2 pages, and I'll it is important. We saw the 6th of June email, and right at the end of that email, if one remembers, Mr. Sully, the General Counsel, was tasked with liaising with Auden's external solicitors. And so this email chain starts on page 2401, at tab 26, from a communication from Auden's external solicitors to Mr. Sully, Advance's General Counsel. Dear Rob, I attach a Delta View version showing changes I've made to the agreement, so the agreement, the second agreement, as against your draft. I meant to send it earlier, the changes aren't as many as they look. A number of definitions have lost their way alphabetically, so I've fixed that. And then Mr. Sully sends the email to John Bayton and to Jane Hill, she's the commercial director, so the senior people, copied to several others. I attach the markup from Auden's solicitors, and I'm emphasising here, is it the case that there is a nod and a wink, or is everything linked to the second agreement? And I attach the markup from Auden's solicitors. It all looks pretty fine, and we should be able to sign on Monday, Tuesday, subject to confirmation of a few points. So the question to Jane and Guy, are you okay with a non-compete that is set out in clause 2.2 as reference to the definitions of product? And he goes on to talk about the non-compete in clause 2.2. Guy, what about Project Kennedy? Is that going to be an issue? As we could always give 3 months' notice. John, I gather that the agreement is that supply starts in June, not July. Well, my understanding is that order and delivery. So this is, the terms have been agreed. By the time of this email that the CMA relies on so heavily and has so attracted my lords, the essential terms have been agreed. And John, I gather you agreed 12,000 packs per month as a minimum volume. Shall I insist upon 12,000? John, for now, the price is still £1 per pack. So this is not some sort of secret deal. This is open and talking about the second written agreement. And one goes over the Okay, so there are four questions regarding the four. There are four questions regarding the second written agreement. So someone called Peter responds. This is on page 2400. Someone called Peter responds to point 3. Would be fine with monthly volumes. From Jane Hill, she talks about it could be just 12,000 per month, or worst case, made up in the following month. So she's talking about volume. And these are all terms that find themselves into the second written agreement. And John Bayton is essentially asked about delivery, whether it is going to be June or July. And my lords will have picked this up, but when this is written, Advance is in considerable trouble, as the tribunal said at paragraph 144 of H2. So let's just, if I can just go to H2, I think it's paragraph 144, we'll see the context that Mr. Bayton is making this. So I think it's 144. It's page 86. Page 86 of H2. And this is why the cross-examination on the commercial rationale was not quite to point. Because one has to realise the facts that existed in June 2014. The things had got incredibly difficult for Advance. It was a culmination of three things. Advance was out of stock because it had terminated the supply with Auden. It had no guaranteed supplies from ASICA because ASICA kept on letting them down. And its customers, by this time, in June 2014, had said they do not want to purchase the child's version. Now, the combination of those three things, out of stock, no guarantee supply, and the customers, boots, wholesalers, not wanting to purchase the child's version, led the tribunal to conclude what it says in Little Roman 3 and Little Roman 4. AMCO was in no position to obtain alternative supplies. We accept that AMCO was doing its very best to obtain such alternative supplies, and that it was ASICA that it was at fault here. So that is a finding that Advance AMCO still wanted to get its own supply. However, for present purposes, what matters is not why there was no supply, but the fact that there was none. The tribunal then goes on. Even assuming AMCO could have obtained supply to sell under their own marketing authorisation, that supply would have been skinny label. AMCO in general, and Mr. Bayton in particular, were aware of the problem for the Plenadrin orphan drug designation gave rise to, which would have presented AMCO with serious problems in gaining market share for what would have been perceived as a new and inferior product. Worth noting that given AMCO had previously been selling a full label product, AMCO would have taken a hit to those parts of the market it supplied. So fair enough, AMCO being able to source and supply skinny label product might have sold less. Then 4, the position, therefore, in this period, June 2014, is that AMCO was faced with a choice, and it underlines either leaving the market or obtaining a continuation of the supply from Auden. Now that is completely different from what what Mr. Bayton was talking about in October 2012-13, and we'll come on to that, a normal generics market. In a normal generics market, one would expect the first generic entrant to price 10 to 15% below and gain a 50% market share. That's what he was saying, why it was bonkers for the allegation of a paid for delay, because in October 2012, had he had product, he didn't know about the problems with the child's version, he didn't know the problems with the orphan designation, and we'll come on to the evidence on that issue. But in June 2014, when he writes this email, that is the situation that both Mr. Sully and Mr. Bayton said they were faced with. Essentially, they had no supply from Asica, the customers didn't want it, and they were out of stock. So when he says there was a bluff, I agree with Jane. If they fall short, they should make up the following month. Having said that, I went in with 12k when I knew that Jane had forecast 10. And we'll come on to her the evidence on that. I suppose at that stage I thought I would settle for debt. As for the start date, yes, it is for delivery this month so that Jane can get the sales this month. I told him that if not, we will launch our own. So that's why he said it was bluff. As he said in evidence, he had no leverage. And he's not talking about a different and common understanding, a nod and a wink. He is trying to get the second written agreement over the line. And the tribunal in H3 accepted that evidence and said that when it came to the second written agreement, the arrangements were, in quotes, a stopgap, which would give Mr. Bayton, Mr. Sully and Advance time to sort themselves out, to try and tackle the orphan designation, to try and tackle suppliers.
Can I try and understand? I'm sorry, my
No,
Trappist vow has now lapsed. You say that what CMA fails to understand is what is said here, which is that the economic background to the negotiation of the SWA, Second Written Agreement, was a situation which was new and different from anything that had gone before.
Yes.
By the time of the SWA, Advance, I call them AM, were in a very difficult position because they had problems with Askia, whatever they're called.
Asica. Yep.
They had problems with getting enough product out of Auden. And
Well, sorry, can I just interrupt? They had they had terminated supply arrangements with Auden.
Yeah.
So they were out of stock.
They weren't getting any. And the launch of the skinny label was not really a big solution for them because that threw the market into chaos, but it didn't give them the benefit they needed because their customers would be unhappy and it would just reduce everybody's prices and make everybody unhappy.
Well, no, that's what. At this point, it was a complete unknown about the price.
But anyway, they couldn't do it.
They could, yes.
There and then they couldn't do it.
Yes.
So they needed, I'm just putting, so the tribunal said they needed the SWA.
Yes.
And they got the SWA, and in H2, in the paragraph you're looking at, 144, the tribunal goes on and says, that was the situation. They entered into the SWA, but there must have been a conversation where they actually said, we won't go into the market, because that's how they got them to move from paying what would otherwise have been the normal demand, £35 a box, to £1 a box, as you'd been doing in the past. And so they say there was some pizzazz, some added something. That's in H2. you say in H3 they realised that those points at that time, in other words, the market difficulty, the failure to the skinny label problem, all those problems were not properly put to Mr. Baton, who was simply being asked generically about some additional common, not additional, but some common understanding, nod or a wink, generically, but absent the real commercial situation as at second written agreement time. And whatever may have been the position before, and you're going to argue about that later, by this time they were up against it, and this was the genuine deal. And the tribunal therefore was correct to say that Mr. Baton had not been taxed with the real position, which was that there was something added to the SWA, bearing in mind the commercial situation of the SWA. He was only put some generic emails which may have led to something different of being the case at a different time. So basically it's all to do with the topical commercial situation of the SWA.
Yes.
Is that your case?
It is. And just with a nuance, arguing slightly against myself, because Mr. Mitriou did say...
did mention the skinny label problem, certainly.
She said, I mean, Mr. Sully said, look, we went to our customers and it was zero, because the chief pharmacist just wouldn't buy it, and she challenged him on that. With a great respect, my submission shouldn't properly challenge Mr. Baton on whether they would get supplies from Asica in time, and so if the court needs a small note on this, the evidence on Advance leaving the market in June 2014, Mr. Turner says it's perverse. We say it was correct.
Sorry, you're going to have to speak up a bit.
I beg your pardon. So, Mr. Turner yesterday said the tribunal on H2 was perverse, I think it was his phrase, perverse, to say that Advance would have to leave the market. We say, when one looks at the board minutes, the witness evidence, that was a serious, serious possibility. So, Mr. Mitriou, with great respect, did cross-examine on whether there would be zero sales. But what the tribunal held was that Mr. Baton wasn't sufficiently challenged on the written agreement being a stopgap. And so the phrase is a stopgap.
Stopgap because of the 3-month notice period.
No, a stopgap because...
Simply because of the position it was in at the time.
Yes.
It had to do something.
It had to do something. Either leave the market and then it abandons its customers, or it resumes, it has terminated supply, it resumes supplies, and then it tries to work out where it can go from there. If it gets product from Asica, okay, it did in August, but then it failed. Customers still didn't want it, and then the market did open up, but it was a stopgap. And the tribunal said that that was a coherent explanation for obtaining supplies from Auden.
Now, if everything you've said is correct, does that prevent it, with X, from being an anti-competitive agreement by object? So it depends what the X is. So all of that is fine. The exigencies the company faced at the time are, as you've stated. Does that prevent it from also having an anti-competitive object if there are these additional elements that Mr. Baton was asked about?
Well, that's why I wanted to continue with the written agreement narrative, because, as I said earlier on, the big difference between the written agreement was I am reserving the right to enter. The market sharing agreement is you're not going to exercise that right. We say that was not put to Mr. Baton. And the tribunal essentially held he was not sufficiently challenged on his evidence that he wanted an express reservation of a right to enter. He wasn't challenged on that. It wasn't put to him, well, you were never going to exercise that right, were you? And it's pretty, I don't want to use the word critical, but it's pretty important.
Can I just ask you about that point? I mean, as you know, if we were in front of the European Commission, where they don't even do much by way of really serious questioning of people under, by way of statutory notices, not the same sort of powers that CMA have. No one would ever worry in a cartel case, assume this is one, that the witness had or had not had a question put to them. And you don't find this sort of debate that we're having in any of the jurisprudence at the community level. And here, you're attaching very great importance to what happened in the cross-examination, and by necessity, playing down all the other sort of evidence. And you said it's critical. I'm just trying to put it into the context of the evidence as a whole, and inferences that might be drawn from chronology, the way the price moves, the way payments are made, things which would give rise to inferences. But how important in the overall scheme of things is a cross-examination exercise in a competition case?
Well, a few points in response to that. With respect to Mr. Turner, he kept on saying there was all this evidence. Well, at the end of the day, where is this evidence? We would like to know where it is, because it's easy to stand up and say there's lots of evidence. We say, actually, when you analyse the 7 emails that he's talking about, there is an explanation for it. Second point is, well, if we were in the general court in the EU, where there is no witness evidence, you would be looking at the documents, and you may come to the conclusion, looking at the documents, that the value transfer is so great that you will draw the inference of a pay for delay. Now, the answer to that is that in our country, we've got the Competition Appeal Tribunal. And as my Lord said in Fenatoin, it is there to ensure that there is an impartial tribunal that for the first time can hear witness evidence and they be cross-examined on it. Because it is recognised that if you just look at the documents without any explanation, then you may make a fundamental error. And so that is the due process, and we should come on to this when I hopefully want to finish the written agreements, but the due process, if we just go to I'm sure that the course, if we go to the authorities bundle, volume 7, because it is very important, what my Lord has just said, to realise what the principle of due process is we're talking about. Because yesterday and this morning, there has been a lot of, again, very smoke and mirrors about the dishonesty point. This was not, we say there was an allegation of dishonesty, but it went much, much further than that. And it does on the question of due process. And if one goes to volume 7 of the authorities bundle, this is at tab 114. Page 4145. So it's probably just worth spending 5 or 6 minutes as to what the principle of due process we were talking about. Let me just clear some.
Xavier.
Authorities bundle 7.
Yes, volume 7, my lord, sorry. It's 4145. This is Phipson on evidence. We're not just talking about dishonesty here. We are the principle of due process that the tribunal was concerned with and has not been addressed by the CMA at all yesterday or this morning is the one articulated at paragraph 12.12. Requirement to challenge evidence. In general, a party is required to challenge in cross-examination the evidence of any witness of the opposing party if he wishes to submit to the court that the evidence should not be accepted on that point. The rule applies in civil cases as it does in criminal. In general, the CPR does not alter the position. This rule serves the important function of giving the witness the opportunity of explaining any contradiction or alleged problem with his evidence. If a party has decided not to cross-examine on a particularly important point, he will be in difficulty in submitting that the evidence should be rejected. Thus, where, during a witness has not been challenged as inaccurate, it was not appropriate for that evidence to then be challenged in closing speeches.
I'm sorry. Yes. The footnote 36 to the heading recites the Court of Appeal in Griffiths and Tully. Of course, that was reversed in the Supreme Court. I'm not saying it necessarily is unhelpful to you, the Supreme Court. It may be something you ought to look at, but...
Well, then we will. I will go to the Supreme Court because there was a very... the principle was endorsed in the Court of Appeal, but it just that the Court of Appeal came to a conclusion. I think it was Lord Justice Bean who said, I disagree, and then it went to the Supreme Court. I would ask the Court to note footnote 40, for example. I don't necessarily need to go to that, but that's Royal Mail, the Office of Communications. That is a CAT judgment, where the CAT, that's under, I think, tab 44. I'm not sure of the volume, if someone can tell me the volume, but that is where the tribunal, in a previous judgment, has referred to Phipson 12.12, and if one goes to that judgment, the principle is also enshrined in the CAT's guidance. But if we go to the Supreme Court, that is at volume 4. It's tab 63. And really, I mean, it's quite an important point on this general principle. It's obviously the last and very important word on it. At page 2333, paragraph 70. The general, so Lord Hodge, in conclusion, the state is an application of the rule in Brown and Dunn. So this is very well-established case law, and the other cases which I've discussed can be summarised in the following propositions. Sets out basically Phipson, the general rule in civil cases as stated in Phipson 12.12, party required to challenge by cross-examination the evidence of any witness of the opposing party on a material point which he or she wishes to submit to the court should not be accepted. That rule extends to both witnesses as to fact and expert witnesses. Adversarial system of justice, the purpose of the rule is to make sure the trial is fair. The rationale of the rule is preserving the fairness of the trial includes fairness to the party who is adduced the evidence of the impugned witness. So it's not only fair to Mr. Baton but to advance. Maintaining the fairness of the trial includes fairness to the witness whose evidence is being impugned, whether on the basis of dishonesty, inaccuracy, or other inadequacy, an expert witness in particular may have a strong professional interest in maintaining his or her reputation. Maintaining such fairness also includes enabling the judge to make a proper assessment of all the evidence to achieve justice in the case. The rule is directed to the integrity of the court process itself. Now, just pausing there, we will see passages in H3 where the tribunal says, because Mr. Baton wasn't challenged on a material point, I don't have a complete evidential record. Cross-examination gives the witness the opportunity to explain or clarify his or her evidence. That opportunity is particularly important when the opposing party intends to accuse the witness of dishonesty, but there is no principal basis for confining the rule to cases of dishonesty. So, for example, just to cut to the chase, when Mr. Baton says, had I had product in October 2012 and 2013, I would have gone into the market independently because I would have priced at 10-15% below the price and got 50% market share, and he wasn't challenged on that. That is a material point, and that is why the tribunal did not feel able to disbelieve him. He was not challenged on that evidence. What you saw this morning, basically, was that he was challenged, and we'll see this when we come to it, he was challenged on the evidence relating to June 2014, when the market was skewed by the orphan designation. So that is, Mr. Donner says I should go to 41, what page that is? 2325. 232. Mr. Donner says I should just ask the court to note paragraphs 41 to 43.
Of what?
Of this judgment. I think that is the detailed case law, which is culminates in the conclusion in paragraph 70.
And the submission you're making now is not really about dishonesty. It's really an issue about the facts.
Correct. And that is a very important point, because there is no doubt that the tribunal was being asked to infer a pay for delay. Everybody accepts that. There was no direct evidence of a pay for delay, unless you say that the bluff is one, but certainly not in 2012, 13, whatever. The whole of the CMA's case was based on inference from various strands of evidence. And to make that inference, the tribunal H2 said, well, I regard the value transfer as a weighty fact. A strong one. And we'll see on that. But the tribunal said, when I'm balancing the facts, the value transfer and the other evidence, Kelly Lifton, who did kill the point in relation to 2012 and 2013, and I balanced Kelly Lifton's evidence and the value transfer and the unchallenged evidence of Mr. Baton, who said it would be bonkers, to use his phrase, bonkers not to enter the market, if I could have done, in 2013. The tribunal weighs all that up, and the unchallenged evidence on a material point carries even greater weight, and the tribunal decided not to make the inference that it did.
So what do you say that the tribunal has said in H3 was not put to Mr. Baton that should have been put? Because my reading of paragraph 43 of H3 is they say that it was a failure to put the collateral understanding that was the critical failure. But you seem to be straying into much broader territory as to what you say should have been put but wasn't put.
Yeah, can I just...
I mean, this is important.
Yeah, it is, yes.
Because of course you're going to say that CAT was wrong in H2. That's the thesis of your notices of appeal. But so far as we're concerned, we have to focus for present purposes on whether or not there was an abuse of process or there was an absence of due process.
Yes.
And that is very important in considering that to see exactly what it is that the tribunal is saying was the failure of due process, and then to test whether or not they're right about that.
Yes. We do obviously disagree with H2, but listening to Mr. Turner, so does he. I mean, he on H2, he disagrees with the finding of dishonesty. He disagrees with the finding of whether the agreements were legal. He disagrees as to the finding that it was a
Well,
side
you're not
agreement.
answering the question.
No, did you? I beg your pardon.
Paragraph 43, page 337 of the bundle, as I read what the CAT is saying.
Paragraph 143
Paragraph
of H3.
43 of the H3 judgment, at page
43 sub
337.
3.
Page 337 of the core bundle, paragraph 43.
43, sorry.
What they seem to be saying in the sub paragraphs here on pages 336 and 337 is it was the failure to cross-examine Mr. Baton in particular,
Yes.
about the existence of a collateral understanding.
There were. Can I just? The short answer to my lord's point is that there was a failure to challenge his evidence on the 50% point in 2013.
Hang on. Sorry.
So
I thought my lord was asking you whether the only thing that they, H3, had said was not put was the collateral understanding. Now, is that correct analysis of paragraph 43? And then tell us what you say was failure to put.
that is. That is.
And this comes immediately after the tribunal's helpful citation of the passages from Toohey and Griffiths in the Supreme Court, which you've referred us to.
Yes.
And then they say, beginning of 43, this is a helpful articulation of the principles on which we were addressed. No need for further submissions. That because the Supreme Court judgment, I think, had come after the conclusion of the oral hearing. And then they say, the rule is for cross-examination one that needs to apply flexibly. Importance of cross-examination so central to this judgment. You make the following points, but if one goes through the points they then make, as I read it, what it's saying is what was not put was Mr. Baton was not challenged about his evidence that there was no collateral understanding.
Well,
as the tribunal.
yeah, I mean, obviously, the collateral understanding, the common understanding to forego market entry, is the issue in the case.
But that was put.
Well, but it is the building blocks for that. So what we're talking about is whether Mr. Baton...
Well, hang on a moment.
Yes, sorry.
This is important because
Yes.
as I read the CAT, they're not saying some of the case about the CMA's case about collateral understanding was put, but some of it wasn't. So it's not. This isn't, as it were, an incomplete challenge on collateral understanding. What they seem to be saying is that there's a complete failure to put collateral understanding.
Clearly, there was...
I mean, you just mentioned the 50% point from 2013. I can't recall that being in H3 anywhere.
Well, it's in spades, and so can I? So the collateral, so Mr. Baton denied the existence of the collateral understanding, as is said there. Why did, and just so that the court knows in bullet point form, what was not challenged? What was not challenged was the 50% point.
What is that point?
That point is, I would have entered the market in a normal generics market in 2013 because it would have been more profitable. He said it would be bonkers to be paid by Auden to delay independent entry. I would have got 50% of the market, and it would be more profitable. Now, on that first point, the CMA refers to the price, and as the court says to me, the price was very advantageous. But to rebut that, Mr. Baton says, I would have got more volume. I only had 6,000 packs. I only had 6,000 packs in 2012, in 2013. I would have got half of the market, 40,000 packs. And we'll come on to the evidence of that. But that is the first point. He was
but
not...
that was, I mean, I don't want to take you out of course, but that was challenged by Ms. Dimitri.
No.
When she said, no, you wouldn't have got half the market. You wouldn't have got 40,000 boxes at that point at all, because it was all rubbish. You had only a skinny label. You'd have thrown the market into chaos. The most you'd have got was what you had at the moment, which was 10,000.
And that, with the greatest respect to Mr. Dimitri and to my lord, is incorrect. It's incorrect because he acknowledged that he would probably not get 50% in June 2014 because the company had realised the limitations of the child's version.
Yeah.
But that he didn't know that in 2013.
Yeah, but he did know it in 2014.
But that's why we need to take this in stages. If we take it in stages, the CMA allege a market sharing agreement, a pay for delay, as from October 2012.
Yes, made by somebody other than Mr. Baton.
What? But
made by Mr. McEwen, who wasn't called to give evidence. Now, if Mr. McEwen had given the evidence you just said to us about 2013, that would be one thing.
Well, again,
he said, I would never have entered into this because it would have been completely bonkers, or whatever your expression was. Well, Mr. Baton wasn't. I mean, on his own case, he wasn't concerned with any of this.
And again, that is not right. The grace from my lord is just taking what Mr. Turner has said.
Will you show us where he says, I looked at this I looked at all this question. I was told by Mr. McEwen what had happened, and this is what I did in 2013.
Well, can I come back to, I mean, we dealt with Mr. McEwen at the trial. We said it would be very, very unfair to draw any adverse inferences because he had left the company like 6 or 7 years previously. We had Mr. Baton and Mr. Sully. The CMA said that Mr. Baton supervised Mr. McEwen. We referred to many documents where Mr. McEwen clearly did not believe there was any pay for delay. And so it is a much bigger point than Mr. Turner just saying there should be adverse inferences. Because...
Okay, look, I'm quite interested in you telling me in a bullet point thing what the points that weren't put. So far I've got the 50%
50% point. That is relevant because it is the start of the infringement period.
Yeah.
That was in 2013, the 50% point. He could have gone in the market in 2013, got 50% of the market. He didn't know about the skinny label problem, so that should have been put to him that he was lying about that.
Well, no, it should have been challenged. So Phipson and 12.12 says it doesn't have to be lying. It's just got to be challenged.
Challenge, yeah. What else?
So the second point is that the tribunal found that in June 2014, his evidence was that the supply arrangements were a stopgap. And the tribunal refers to the word stopgap, and that is in his evidence.
Yeah.
And the tribunal considers that he was not sufficiently challenged on that stopgap. I needed time in order to sort myself out. The third area is that the tribunal finds was not sufficiently challenged, is the point that I was trying to make a bit earlier, is that Mr. Baton said, I covered myself by instructing external lawyers to record and negotiate the commercial terms for the supply. Now, the CMA say, well, we see the written agreement, but there was a broader, different understanding that you would forego entry. Bullet point form, express contractual right to enter. CMA say you won't exercise it. That was not challenged. That was not not put, but his evidence wasn't challenged. That's the third point, which was not the tribunal said was not sufficiently challenged. And the fourth and last, so all those three have nothing whatsoever to do with dishonesty. 50% stopgap, the written agreements recorded the whole bargain. Nothing to do with it, dishonesty so far. The fourth one is dishonesty. Because the tribunal did interpret the decision, see paragraph 10.115 and the sham, did interpret it as alleging serious misconduct and dishonesty or serious misconduct was not put.
I mean, is there a difference between serious misconduct and dishonesty?
Well, the tribunal did say that this wasn't kind of dishonesty in the criminal sense. It was, that's why I use the slightly unfortunate phrase of naughtiness or. But I
always find that rather strange in competition cases. I suppose the more money you steal, the more respectable it is. The competition cases are worth hundreds of millions of pounds, which people walk off with illegally, and that's said not to be dishonest. I think that's fair enough.
But I mean,
It's called white collar.
if a public authority says there is an intentional breach of competition law, you don't have to know about Chapter 1, but there's an intentional breach of competition law. You've intentionally agreed a market sharing arrangement, and you have failed to disclose that from your solicitors, who are scrutinising the arrangements from a competition law compliance perspective. And the allegation is you've failed to disclose the broader and different understanding. Solicitors are drafting the contract to give advance the express right to enter. And the different and broader understanding is you will never exercise that right. Now, if Mr. Baton had...
That's point 3 of your point 4.
That's what,
I mean, your point 4 is really an overlay to all the other 3 points.
it is, yeah.
You say, I mean, I think I summarised it right earlier. you say, look, there was all this commercial background, as at 2013, 2014. The cross-examination proceeded upon a generic basis without really challenging the cornerstones of the defence that was being put forward.
Correct.
And Mr. Baton had explained in full detail in his statement why he was a decent chap and hadn't intended any wickedness, to put it bluntly.
Yeah.
And he'd got cover from his lawyers. He really did want to go into the market. He was in a real bind, and this was only a stopgap, and this was therefore not unlawful. And it should have been put to him, no, chap, you knew this was unlawful. You knew you'd agreed not to do what was written on the paper. And it wasn't put that way.
And I would like to take the court to how the tribunal articulated that point in the due process hearing, because the tribunal said to the CMA in the due process hearing, I had referred to the two emails, the 6th of June, and there was another one we haven't seen, the 18th of June. And the tribunal says, well, what should have been put to him, but no question is put to him about how could you possibly say what you're saying in this email where in the light of what we are alleging.
I mean, what I'd like you to deal with at some point is the bit that I find difficult about the tribunal decisions at the moment, which is the disconnect between the sort of, it's almost like a sort of a sea change that takes place between saying this is the worst infringement of competition law I've ever seen, from somebody who knows an infringement of competition law when they see it, to saying it's not. And it seems that the factors that are relied upon in Judgment 2 are then not carried through to Judgment 3 when there are all sorts of other arguments and one might almost say argumentations put forward which support the proposition that the case wasn't put. But you don't see that put in the same way in Judgment 2. So it's sort of, one is left asking the question at the end of it, hang on a sec, don't you remember what you said in Judgment 2? And I mean, I'm open.
I wish Judgment 2 had never seen the light of day. I think I would have preferred a composite judgment.
Also, the fact, and in a sense, it's part and parcel of the same point, the fact that the tribunal actually goes out of its way to say in Judgment 2 that Mr. Baton had lied in the witness box.
Yes.
So which one? And one then has the puzzlement. Well, if the tribunal thought he was a liar, then what difference would it have made if there'd been a slightly more elaborate cross-examination than there was? Now, that's obviously a question of degree, but that's one of the things that troubles me.
Just to add to your woes, we have 20 pages of cross-examination by the tribunal and Mr. Holmes and Professor Mason, all of which was on the predicate, essentially trying to test the CMA's case, and they never came up with the idea or the solution that they then come up with in hydrocortisone in H3. I mean, what was in the tribunal's mind when they went into such an elaborate cross-examination questioning themselves? Which was really about inferences, what you draw from the facts, where the incentives lie, where the leverage lay, and so on and so forth. It wasn't in their mind at that time. And then they come up with a conclusion that's a flagrant violation.
I'll try and answer these questions.
Somebody will be taking a note for you, Mr. Brealey. I've got yet another one, which is, if you're right,
yes,
right, and I see the if I may say so, energy and verve with which the points are put. Should you not be asking for a retrial of all this? Should you not really be saying this all went terribly wrong? And forget the money, but this wasn't fair. And because of the disconnect and the problems and the failure to answer some really fundamental questions as to the economic situation, which is what competition cases are all about, really you should go back and do this properly.
Well,
In
the
one
straight
go.
answer to that
one
is
go.
no, because
No.
we are essentially the respondents to an appeal.
So you say you should just, the appeal's wrong because the tribunal was right,
Yes.
but then what do we do about the findings that seem compelling at first sight in H2?
Well, so just to it's not always wholly clear from the two judgments, as I'm sure the court will appreciate. What again, bright line point. H2 was more concerned with inferring a pay for delay from the documents.
Yes.
If I can just, is it paragraph 16
Yeah.
of H3?
And I think we can accept that without looking at it.
Yes, it is paragraph 16. It's the last sentence.
Yeah.
16. The failure of due process fatally undermines the conclusion otherwise open to the tribunal that there was sufficient material to uphold the decision when considering, in substance, the documentary evidence alone. And 7. Paragraph 7.
Yeah.
So, in paragraph 7, right. So that was the primary basis upon which the tribunal in H2 concluded an unlawful pay for delay. What happened, and I'll try and navigate through, was that the tribunal was concerned that Mr. Bayton and Mr. Sully, but Mr. Bayton had explained the position, explained why the inference of a pay for delay from value transfer and the other evidence should not be made. So the tribunal was concerned that his explanations had not been sufficiently challenged.
But it was also concerned that the explanations were dishonest.
Well,
I mean,
That's the point I was making.
how do you square that?
well,
The dispute.
and just to make my life a little bit easier, if you look at H1, and I've got the note of it.
I was going to say, oh, please no.
No.
Where is H1?
H1. Well, I can read it. Well, it's in the unagreed supplemental bundle.
Right.
But I'll just read what the tribunal says in H1.
Really give me the paragraph.
It's paragraph 26.
So give us the reference.
Okay, well, it is
27.
volume 3, page 2101.
For the avoidance of doubt, I have read a lot in this case, but I have not read H1. If anybody wants me to, they're going to have to show me a jolly good reason why.
Okay, so which page?
It's page
Internal page 18.
internal page 18.
We've only got some of it, have we?
No.
Looks like.
So I'm trying to find my.
I have the whole.
Well, the judgment seems to be 150 pages, but we've only got selected extracts.
It would indicate my lord is in the same position as the presider here.
Does the court have paragraph 26?
Yeah.
Yeah.
Right, so just, Mr. Baton was an impressive and knowledgeable witness.
Oh yeah.
He gave his evidence precisely and was extremely articulate. His knowledge of the pharmaceutical industry was both profound and detailed. So he was described in H1 as an impressive and knowledgeable witness.
Yeah.
In H2, as the court knows, paragraph 153, he was dishonest
And a liar.
and a liar.
Yeah.
Well, you can be impressive. I mean, I would
Some of the best
hesitate.
liars are.
I would hesitate to say that I've met some.
And then in H3, the provisional findings against Mr. Baton are unsafe and repudiated. So I agree that the question is, how could you go from saying he was an impressive witness to a liar and then repudiating the description of him as a liar, and I guess we go back to him being an impressive witness. And the reason is that H2 was based, as the tribunal says, on an incomplete record. It based the findings, its provisional findings, on the material it said it had. You then go into the due process hearing and H3 because the tribunal is concerned that certain explanations, positive, it calls positive evidence. You see the phrase time and time again in H3, positive evidence was not challenged. And not only was it not challenged, the tribunal finds as a fact that the explanations were coherent. And that's another reason why you can't just disentangle dishonesty from H2. There are many reasons why you can't, because there's the legal point, the side point, the Lifton point. But in H3, the tribunal undoubtedly makes certain further findings of fact.
What you say really is, I mean, I think I'm getting it now. Mr. Baton's brain was different from what went before. It's not good enough just to say, well, there was a transfer value. Before that was all terrible and anti-competitive, and it was the same in 13-14. Actually, Mr. Baton said it wasn't the same in 13-14. There were all these complexities and difficulties, put me in a much different position. I got the lawyers to cover me. I knew what had happened in the past, but it wasn't what I was defending in 2013-14. I was doing my own deal, and I was doing it for good economic reasons, and that was an explanation that was put to the tribunal and never properly challenged. And that is unfair, because the tribunal got it wrong really in H2, and then sort of half put themselves right. What I was going to ask you was, it's a pretty funny way to deal with it. I've never seen any case like it. It's probably why I'm sitting here. You know, I've never seen a case where the tribunal says, I've reached firmly this conclusion, and now I want a trial about whether I should give effect to this conclusion.
Firmly provisionally concluded.
Firmly provisionally, well, but flagrant, I mean, words like flagrant, and this is the worst thing I've ever seen, it's terrible.
Yes.
And then bang on, okay, well, that's all terribly unfair. We're putting the whole thing away, 100 million quid chucked in the air.
And also, you know, Mr. Baton, although it stayed, has a director's disqualification application over his head because of this.
No, I mean, well, Mr. Baton, if he's been unfairly treated, then it's very serious.
Yes, and Mr. Sully
Completely get that.
various times said there is an allegation in the decision of a sham that certain individuals did not disclose his common understanding to Pinsent Masons. This is, for me, career ending. Which this is why we can't necessarily just brush serious misconduct aside.
Now, your point about this is that it was too generic. It was too much of a broad brush applied by the CMA, and they didn't really take notice of what Mr. Baton was saying. You called Mr. Baton for a reason. You couldn't call McEwen. He was long gone. What he has done may or may not be good, bad, or indifferent. But Mr. McEwen does not say what Mr. Baton was doing. I mean, there may be an argument about whether Mr. Patel was the same Mr. Patel, but let's leave that aside for a moment.
I mean, so, and I will probably tomorrow, but it is important to look at the chronology and his evidence for the first period.
And you should probably tell us to really read Mr. Baton's witness statements, should we?
Yes, and Mr. Sully's.
And Mr. Sully, but Mr. Sully, of course, is a lawyer.
Yes.
Still a lawyer.
Yes, he was the general counsel.
And you couldn't give me the references to the witness statement.
Yes, so it's in supplemental bundle 1.
Yeah. Call.
No, it's the agreed supplemental bundle.
Right.
Tabs 1 and 2.
Oh, right at the beginning. Okay. And that's 2 from Bagent and Sully. That's it, is it?
Well, then we did have Kelly Lifton.
Yeah, I know.
And Middleton, but he's not in there.
Middleton.
Well, we won't bother with him.
No.
He was also, we also called him because there's no doubt that the CMA said value transfer, and lo and behold, you went slow, you delayed development in 2013. And that's another reason why we can infer a pay for delay. The value transfer, and you went slow, you delayed your own development. And we went to town on that second point. We adduced hundreds of emails which showed Advance trying to expedite development, to be the first mover advantage, to be the first mover, the first generic entrant. And we adduced Kelly Lifton. And that's where and she did kill the delay point. She wasn't really concerned with, Mr. Turner says, well, she wasn't concerned in August 2014. She wasn't there when she said that. But she was heavily involved in killing the delay point in 2013, early 2014. And the tribunal was totally correct to find that. And I think Mr. O'Donoghue is going to touch on that. And I'll just refer a few emails tomorrow.
So it's all about timing, really.
It is. And while we're on timing, again, I think my Lord asked me a question about it's all the wrong way round. And we see this.
Well, I see the point. I see the answer to that now. You say it's not the wrong way round because the tribunal was concerned with 2014 when the second written agreement was entered into, at the earliest 2013, which was concerned with the Baton era, and you should have been looking at the commercial situation of the Baton era.
Yes. And
it's not fair to just say this is all sits end to end with a very suspicious history, which I described pejoratively, I'm afraid, this morning. But the tribunal did that too in H2, and that's not the whole story in 2013, 2014, and it was different and it wasn't correct that you picked out the 2014 agreement as being something special. That was your witnesses who were explaining the commercial situation.
Right. And in H2, paragraph 147, it's page 484, we see how the very first period.
So H2,
so H2, page 484.
Yeah, but it's
484. 484?
Paragraph number of the judgment.
147.
Yeah, that's
147, sorry.
I mean, I think I'm going to say something in any judgment I write on this case about the need to avoid lengthy sub-paragraphs. Because this has caused me absolute annoyance.
Yeah.
Maybe the only thing anybody ever gets out of this case.
It's a small point, but it's a very, very important point. So we see at paragraph 147, our conclusion, the second written agreement was a more aggressive manifestation of what had gone before. We're not in a position to say with any precision how the agreement with Auden was concluded. And then the first 18 months of the alleged infringement, there's very little analysis of why there is an infringement from October 2012 to June 2014. And as I say, if the tribunal does then go into H3, looks at the explanations for the early period, and then concludes that I can't make the inference. But that's why it is important, because Mr. Bayton says he did inherit an unwritten supply agreement. And in my submission, there is very little doubt, if one looks at the documents and the evidence, that Advance acted totally inconsistently with any pay for delay.
Sorry, who did?
Advance, well, AMCO, sorry, AMCO, I'll call it AMCO.
Advance acted inconsistently.
With any pay for delay.
How?
Because we will see maybe in a moment, in October 2012, there was a Deloitte report that was given to Sinven, which said that it was important to get into the market early, be this first generic entrant. And so Mr. Bayton was cross-examined on that, and his evidence was that it was very important to get into the market early because of this 50% point.
Mm-hmm.
We then have many emails from AMCO's technical department saying we've got to get this on quickly, ASP, this is important. So there was the documents show that AMCO wanted to develop its own product quickly.
Yeah.
Supported by the evidence, who had no skin in the game, Kelly Lifton, who said that the delay in developing was all ASICA's fault. Kelly
Lifton said they were on her back the whole time, effectively.
Yes, but she said that AMCO chased her and her company was a nightmare, basically, and the tribunal accepts that.
Third point?
You have contemporaneous documents that I can show the court where the commercial director says, are we going to compete with Auden? And the answer is yes. There will be two of us competing. So there are documents showing the intention to...
And Bayton said yes.
And yes. And then the next point is that there is a board meeting in, I think, the 29th of January 2014, where the AMCO board record the termination of supply with Auden and the launch of their new product.
Termination of supply with Auden and launch of new product.
And the
skinny
launch
label.
And the last but not unimportant point is Auden's reaction to that, which was Project Guardian. And I can show you a document on that tomorrow.
What is it?
Project Guardian was, as the name implies, to preserve its market, not by any pay for delay, but by disparaging Amco's child's version. And it blitzed the pharmacies, saying that Amco is coming onto the market, but don't dispense it because it is a child's version. You should not dispense it for adults.
So how do you explain in a sentence the cancellation of the 10 milligram production and the letter to the staff saying, I'm really sorry, I know you've worked really hard on this, but we're going to stop it for the moment?
In a word, at the beginning, confusion. So CMA picks up a stray word or two from one particular person, says it's been suspended. That is factually incorrect. As Mr. Baton said, it wasn't suspended. It might have been suspended for two or 3 weeks, just after they had signed the written agreement. But again, if one looks at our Annex 1 of our closing, we adduced many emails showing Amco/Advance trying to continue to develop its product through ASICA and through other means. And Mr. O'Donoghue will come back to that.
Okay.
So it is not correct to say it was suspended. It may have been suspended for 1 or 2 weeks. They just signed the agreement, and then various members say, well, what's happened?
I mean, it may be said against you. That's a bit strange then to write that email to staff saying thanks so much for working so hard and doing all this. I'm sorry, but you know, business is business.
Well, one has to remember that they had just signed a 2-year agreement,
Yeah.
which, on the face of it, the CMA say is not unlawful. And when, and I'm sure Mr. Donoghue is going to come to this, but when Mr. Baton is cross-examined about the suspension, it is all by reference to the contractual terms.
Yeah.
And the documents say, right, well, we are not going to launch because we're contractually obliged to buy the product from Auden. And so there is a confusion on the cross-examination on the suspension point about which agreement are you talking about? Have you suspended it temporarily because of the second agreement, or for some broader and different understanding? And that's never made clear. And that's something Mr. O'Donoghue will discuss. But if one looks at the cross-examination, the documents talk about, well, we're contractually obliged to do this, we're contractually obliged to do that.
So how long have you got in your scheme of things?
I don't know. Look, I would. Maybe I can.
Well, I just wanted to know where you're going now.
Well, where I'd like to go now, and probably then finish, and then Mr. O'Donoghue can maybe start
Pick up the baton.
pick up the baton, not drop it. And, I'll just.
That shows a lot of faith.
A lot of faith.
Yeah.
Can I just go through the evidence of Mr. Baton?
But the plan, I mean,
Yeah.
just to give me the big picture, the plan is Mr. Turner's taken a day and a half.
Yes.
You guys are going to take a day and a half.
I think so.
So you intend to finish by tomorrow
Oh,
night.
yes.
And then that's Friday night.
Sorry? We may still some of our reply time.
Okay.
In other words, you may go into Tuesday.
Tuesday, yes. And you're going to have to tell us at some early stage if anybody thinks we need Wednesday next week.
Well, I think we probably do, because we're going to have to deal with this application for permission to appeal by the CMA.
Yeah, okay.
Which does raise a whole host of respondents' notices, procedure. Are they the only grounds?
Well, you're going to, I mean, just so you know, you better start thinking about what you want to put in your respondent's notice to that appeal pronto. Don't tell me you haven't had time later. I mean, I think we intend, I think I said this last time, to hear everything.
No, of course, yeah.
Yeah.
But it's not whether permission should be granted or not. It is whether it is a good application or not.
Yeah, no, of course.
And we only got it this morning, and
No, I understand.
Yeah. Okay, so where are you going now?
okay, so for the next 15, 20,
16 minutes to be precise.
16 minutes, I might. Okay.
Yeah.
Can we go then to the cross-examination of Mr. Baton?
Yeah.
This is on commercial rationale, and this is the start of the infringement period, which is a critical, because he inherits this, and we say he and the company acted completely inconsistently with any pay for delay.
So the start of infringement period is what?
October 2012.
Yeah.
And I'm looking. I need to go to supplemental bundles.
So this is the takeover from Waymade.
Yeah. Yes.
Hmm. Waymade have never been in this case? Waymade have never been in this case?
Not that I'm aware of. No.
Well, Mr. Brealey, you've been in this case, haven't you, since it began?
I have.
Yes.
Well, you might remember.
So don't feign ignorance with me. That's when I was going to.
Jeez.
Mr. Turner's allowed to be feign ignorance, but you're not.
You can. So supplemental bundle 1. This is I think tab 6, and if we go to so I think my lord has the electronic bundle, and then there is the hard copy bundle. So I think the electronic bundle is 425, but the hard copy is 422.
Yeah. I can add 3 if you want to use the hard copy.
Page 110 of the transcript.
This is Mr. Bajan.
Yeah.
Baton.
So this is Mr. Baton. This is the start of his so maybe I don't know if it helps to just do the internal, but anyway.
Cross-examination started on the previous page.
On 424 on my bundle, this is when the cross-examination starts, and at line 18 of transcript 109, my 424. Which is on the hard copy, is it 421?
Yeah.
So, just to pinpoint this, CMA say, you said, Mr. Baton, in your witness statement, you've been in the pharmaceutical industry for a long time, 39 years, managing director of Teva, which is a big company, obviously. You were CEO of Gold Shield, but I think it's fair to say, is it not a huge amount of experience in this industry? He says, yeah, that's right. It goes on, and at line 10, and you have got experience of what happens to market after generic entry. I certainly have that. So it is important to realise that this man has considerable experience.
He's a big guy.
He's a big guy. On this page, at page
With
40,
presumably a substantial industry reputation.
yes, and I can say without giving any confidence away, the finding of dishonesty in H2 has been serious for him. It's not even if it's been repudiated.
Right.
Anyway, 425.
Completely get that.
Here we go to creation of AMCO, and so for the next few pages, 425, over the page at 426, it's uncontroversial, but you know, he is a big gun, but he's also put these pharmaceutical companies together. So in essence, he was the CEO of a company called Mercury Pharma. Synvent, Mr. O'Donoghue's client, purchased Mercury, and then Mr. Bayton helped Synvent purchase Amdipharm to create AMCO.
Yeah.
I'd like to pick up the story, the narrative, on 427, so hard copy 424, at line 16, and we'll also go to a document which is in the unagreed bundle at tab 21. So this is the Deloitte due diligence report.
Page.
Well, it's to identify the document. It's page 1654.
Is that volume 1? Volume 2?
That is volume 2. Volume 2.
Project Ample.
Yeah, that's basically Amdipharm.
I thought
This is Deloitte. The reason I'm taking this is because it is. You see this on the page, 23rd of October 2012.
Yes.
So this is the beginning of the infringement period.
Yeah.
And there's just an extract from it, but it's page 12 of the report. Page 1656, 1656 of the bundle.
Yeah.
Right.
So there's a lot going on here. I mean, obviously hydrocortisone is not the only product. But we see on page 12, hydrocortisone, and then on the right-hand side, the current market for hydrocortisone tablets is supplied solely by Orden Mackenzie. Management plan to launch their product to take a share of the market. High risk of other new competitors in addition to Ample, that's Amdipharm, which would impact market prices. However, Ample, that's the company, may be able to get to market earlier than other suppliers because they own the original MA for this product. So what I just want to emphasise...
Synven is the takeover company.
Yes, yes.
And that's reducing what the management have estimated by 30%. But the plan that was being put forward by management in relation to the takeover was they were going to come to market and they were going to make use of MA.
And the important point is to get there early, before the others.
Yeah.
That's important to the 50% point. So we can put that document away, and we
Is
just
that
go...
document referred to in either H2 or H3?
I have to...
Pretty certain it's referred to in one of them because I know there's a reference to a Deloitte report.
It may be in H2. Someone could check that for me. I'll do a quick search. If I can go back to the cross-examination...
Not in H2.
Seen it somewhere. Yeah.
On page 427, that's 424. We see that. I just want to look at the final due diligence report, which is at H150. You can see the date on this, 23rd of October. Refers to the acquisition of Amdipharm. Yes, you'd have seen this document at the time. I would. Do you recognise it? Yes. So he was involved at this time.
Yeah.
Over the page, on page 429, that's obviously 426, the hard copy, he's taken to the report, which is the page 12 we've seen, and the question at the bottom on line 10 and 11, high risk of other new competitors coming in, which might take potential market share, but the idea is to get into the market earlier, yes, and he confirms yes. So his evidence, again, and this has been put to him by the CMA, he wants the strategy is to get to the market earlier, and then the last bit on 4 is on 434, that's 431 of the hard copy, where the question is line 10. Now, the due diligence material does not, as far as we have seen, refer to any supply agreement with Auden. And I think that is because the focus at this stage was on the launch of a new product. Is that right? Yes. This is what we intended to do with Andy Farm business once we bought it. So the CMA is actually putting it to him, but it's essentially what Deloitte says. But he has seen this. He's part and parcel of this. What we want to do is launch the product. Now, this exchange is relevant, as I say, to the 50% point. So if one goes to page 481, and I hope Mr. O'Donnell will allow me to just finish this tomorrow. If we go to page 481, I know we've seen this, but it is, again, it is so important for what the tribunal decides in H3. It's line 7 on 481 to line 16.
Sorry, you'll have to tell me what the words are, because
Okay, sorry. So
the
on
way the
page
negotiation works is that there is give and take. We were taken to this morning.
it is.
Right.
But the important evidence is at the bottom at line 24.
Yeah.
And then you look at this thing, and what the CMA is asserting is that somehow we had got into some pay for delay discussion. So he does know what it is because he's a clever man. We got into some pay for delay discussion. It really kind of does not make sense to me or to him because he's supplying me with 6,000 packs. The important thing is 6,000 packs a month. And as counsel rightly says, he's effectively losing that money himself. And I am developing and getting ready to launch my competitive product, which will not be 6,000 packs a month. It will be, the market I think was something like 80,000. So I would have been able to launch 40,000 packs a month. So the whole premise of this case just does not make sense. Why would I accept to delay my product for this measly amount of stock? So I said earlier on that the CMA emphasised price to infer the pay for delay. You're getting a fantastic deal. What he's saying, well, I understand that, but I'm not being paid because I would sell a lot more in this market. And we'll come on to the cross-examination tomorrow, but that is his evidence. And then over the page,
And he uses the word measly twice, actually. Because
I think it's a northern phrase, measly. I don't know, but it was.
we're not going to be prejudiced in this court.
Well, no, I grew up in Lincolnshire, so it probably comes from Lincoln.
It's a Midlands expression. I come from the West Midlands, who certainly use the word measly.
Measly, yeah.
I don't think it's a northern expression
I
at
don't
all.
know. Anyway,
All right, sorry. I translate.
he uses that measly point, and it's also cited in H2.
Yeah.
Paragraph 7, maybe 70.
Yeah.
Well, it's the paragraph is completely
Yes.
impossible to understand, but it's paragraph 118 or 19 when he's citing a great passage from the cross-examination, from his own cross-examination, the president's cross-examination. Anyway, his point is, why would I do it for
There's so little of it.
why would I sell it for so little? 6,000 packs is nothing to me. I can get 50% of the market. That's 40,000 packs. Who knows? We may even expand this market. I'm a big guy.
Yeah.
Don't buy me off. That's nonsense.
But he says that, and I get there's no disrespect to Mr. Meter, but at line 17, it's not challenged. It's just I want to ask you, I want you to speculate as to what might have been in Mr. Patel's head. So
Well, there is that, and then she also says, you couldn't have done 40,000 right away.
No.
but that is much later.
Yeah, because you've done 40,000 in October 2012.
Yes, I'll come to that. Yeah.
Well, of adult as opposed to skinny label.
Well, he didn't know that then.
Okay. Well, yes, he didn't know that then.
Well, he may not have known it. But just there is a
As a
question
matter
there as to whether he could have done.
As a matter of fact, he probably would have been very, very disappointed, as he was disappointed in May, June 2014.
Well, that's why I asked you the question, because logically it would seem likely that if he couldn't get it done in June 2014, he was unlikely to be able to get it done in October 2012. Well, I follow the point that in October 2012 he didn't know that all he'd be able to get was skinny label.
And I won't go. If I could just finish this. So I don't want to lose the thread, but if one goes to page 565 on day 3,
Right.
I don't know if that's in the same bundle.
That's right.
I'll just finish with this because it is the
Yeah.
so it's 565 I think for my Lord Master Rosen
562.
562.
Yeah.
But this is an important point. So at line 10, again, actually, my thinking at the time would have been the thinking of any person such as Mr. McEwen or Mr. Patel. There would be no point at all in having an agreement that allows us not to launch the product in return for 2,000, 6,000, 12,000 packs when the market is 77,000. So the comfort you are, this is the President, is that you were getting less from Auden than you ought to get if you had a product to launch that was a rival. Yes, okay. The answer is, and this is a very, very important answer, because instead of making 6,000 times 38 in sales, I would have made half of 77 times 38. And this is the bit I emphasise. By the way, if you remember, at that point the orphan issue was not known by us. So we assumed that in a normal generics launch, we would achieve 50% of the market, maybe more, maybe a tiny bit less. And the point that I emphasise is that he's talking about a normal generics market. And we'll see tomorrow.
And the point about half of 77 times 38 is that his thinking was that Amco would have bought from Asica at £1 a box or whatever. In other words, the price would have been the same.
So he would have. It would have been a similar cost of goods. Actually, it would have been a better cost of goods from Asica as it turned out. But the point he's making here is that with his Asica product, he would have taken Auden's market price, discounted by 10-15%, not massive.
No, I
yes,
understand the point.
that would have been.
Just want to know where the 38 came from. The 38
is from
what he sell on for, what he was buying in for.
So the $64,000 question is, so why was Auden selling you this stuff at £1 a box?
I could show you another email where Mr. Baton says, I don't know what, a contemporaneous document, it's in our skeleton, I have no idea why he's doing it. If I were him, I would tell us to PISS off.
Sorry, I didn't get it.
For the transcript.
Turn it off.
But that was, he did, it didn't make sense to him, and I can show you the email tomorrow, but internally he says, I've got no idea why he's doing it. If I was him, I would personally PISS off.
Yeah, okay.
So I'll spend just 10-15 minutes just finishing this.
Mr. Patel is a man who sometimes just says yes.
Well, we don't know what was in this. Maybe it was, as Mr. O'Donoghue I think will articulate tomorrow, this did start off as an abuse of there was an abuse of a dominant position by trying to incentivise someone to stay out of the market. But that got abandoned.
Right. Good. Okay, well, thank you very much, Mr. Billy. We will see you all at 10:30 in the morning.